Good afternoon, everybody. My name is Ali Bulurci. I'm a volunteer with PICRA. I'm your host tonight. Uh, I'm gonna introduce you to the uh, main speaker of this afternoon in a minute. But before that, let's let me say something about our today's market. First of all, happy Nowruz, Nowruzatun Khojastu Piruz Bad. I know that this Nowruz doesn't feel like Nowruz. We are in uncharted territory right now with this coronavirus that everybody hopes that it's going to disappear the way that it appeared a couple of months ago suddenly, and we never hear about it again. But anyways, everything is going to stop, and the government of Ontario has announced a state of emergency, but put real estate business as an essential service, but it's not business as usual for us as well. Well, federal government had promised a stimulus package of almost $100 billion in cash and tax withdrawals. Ontario government has announced that they're going to help people with $17 billion financial help. And even tonight, the Bank of Canada lowered its target overnight rate by another 50 basis points, decreased it to only 0.25%. Never before you heard about these kind of rates. And they're talking about negative rates like what they have in Japan. That's why we at PICRA, with all the volunteers that are helping us in the behind of the scene, are here for you to help you with providing the latest information and education to help you cope with this unreal reality. For tonight, we are having Mr. Yemi Asalu with us. Yemi is a partner with the law firm of Korman and Company Professional Corporation. Korman and Company specializes in real estate corporation, property and corporate and wills and estate practice areas. Yemi got his degree from Lagos State University and an L.L.M, Master of Laws degree from Osgoode Hall Law School of Toronto. He was called to the Ontario Bar in 2005. His legal experience ranges from corporate in-house, having started his career at PricewaterhouseCoopers, to the traditional law office. So without further ado, please help me welcome Mr. Yemi Asalu to the webcast.
Thank you, Ali. Welcome, everybody. It's great to actually see this many people turn out to participate. Very thankful. It's going to be a great use of our time for the next 1 hour. If you have any questions at all, feel free to leave it in the comment section, and I'll try to get to it as soon as possible. We'll be talking about a wide range of things this afternoon. Most of it centered around the COVID-19 pandemic and how it affects the way we do business. So, as Ali has given a brief introduction into what's going on, there's a state of emergency currently in Ontario. So the Premier has announced a state of emergency as a result of the COVID pandemic. What does it mean for you? What does it mean for us? It's not business as usual. Good news is you and I have been classified or categorized under the essential services list. That allows us to do business, but how we do business is a different story. How do we go about our day-to-day business? How do you do showings? How do you do open houses? Well, the reality of it is that at this point, you're being urged to not do open houses. You're being urged to not do in-person meetings. And the whole idea behind it is to is to flatten the curve. So the spread of the virus is accelerated when there's direct contact. So that's the reasoning behind it, quite frankly. But it's our livelihood, so we're having to strike a balance there between getting our jobs done, in a way that's safe, in a way that's safe for you, in a way that's safe for your clients, which you, in actual fact, morally and ethically, professionally, ethically, owe to your clients as well. So the single biggest change in how we do business today is the in-person versus the virtual option. We're conducting this meeting. This is a virtual meeting, as you can see. So this is keeping in line with a recommendation from public health agencies in Canada, and now with our professional bodies. Otherwise, we'd be in a room full of people and having the same conversation. But nonetheless, if this is to be a lesson or an example in how to do business, is that we can still get it done. We can still get it done. We just have to do it differently. Up until now, a number of agents that I work with have utilized virtual, like digital way of doing business. For them, this change wouldn't be drastic because they've always done it anyway. For other people who've always preferred the traditional way, I'll call it, the traditional way of doing things, it might be a tougher adjustment to make. But regardless, it's one that is doable. My recommendation for practice or best practices is to connect with your colleagues who already employ digital technology in carrying out their business and just find out how they do it. Just find out how they do it. It is doable. This might not go on forever. Hopefully it doesn't go on forever. But we'll learn a thing or two from it. And that's the way that I approach these things, is that we'll learn something, we get to adjust something, and we incorporate it, hopefully, into our practice moving forward from this point. I've highlighted a number of issues that we'll talk about. A lot of things, this is unprecedented, just so you know. So there aren't ready answers out there. What I'll be doing is identifying a number of scenarios, a number of issues that you have to bear in mind when you do business. We can then talk about how it impacts you, how it impacts your business, while navigating this uncharted waters. Really, is what this is about. We'll start off from how to even do business in the first place. Keeping a database of your clients, reaching out to them via email, via video conference calls and things like that, checking up on them, making sure that you're sending you're showing concern in this time. And with respect to actually conducting the business itself, with respect to doing showings, virtual showings would be the way to go now. Yes, you can use pictures, YouTube videos, or what have you, but virtual showings are the way to go, essentially. So if you're not working with a videographer, maybe connect with them at this point. Make sure they're able to work as well, because they might have issues moving from place to place. So make sure that whoever you do work with is comfortable to doing work. The agreement of purchase and sale indicates that the buyer has had the opportunity to inspect the property. Inspection of the property assumes a physical inspection, which means that if it's being done by way of a virtual tour, or if it's being done by way of pictures, is that the buyer has not actually done an inspection. Now, if the agreement gives the buyer the opportunity to do an inspection, but the buyer couldn't do an inspection because of the pandemic, what you'd want to do as an agent representing a buyer is to take out that clause. In taking out that clause, you're somewhat protecting your client because that clause actually gives the seller some degree of leverage should there be a post-closing issue. So in a typical example, you close a deal. Buyer finds out there's a problem with the property. Seller says, well, this problem, quote unquote, has always been there. This problem was there when you inspected the property. So the onus is on you as a buyer. And then there's a doctrine called caveat emptor, which is buyer beware. So which puts the onus on the buyer to satisfy himself, herself, as to the quality and the functionality of what it is that you're buying. So it's on you to make sure that what you're buying works properly, what you're buying is in good condition, which is why the seller would turn around and say, no, 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 this existed all along. You should have caught it. Either you, your inspector or you should have caught it in an inspection. So this is totally on you, and I'm not responsible. Now, because now we're doing virtual tours, how much of a defect in property could be revealed from a virtual tour? So those are the type issues that I foresee us dealing with going forward, and the way to mitigate your client's liability, which indirectly is your liability as well, which could be your liability, is to put in clauses in the agreement that protect either side that you're working with. So if you're working with a seller, you want to throw in a clause in there that says that the buyer is satisfied, for example, is satisfied with a virtual inspection, with a virtual tour, and notwithstanding the fact that the buyer hasn't had or did not have the opportunity to visit the property or to inspect the property physically. So in doing that, you're protecting your seller client in case a post-closing issue was to come up, and it shows that everyone's had a chance to address it and to speak about it. It protects you as a buyer agent too, in the sense that you don't want your buyer client turning around and blaming you for having conducted a virtual tour and then found all these defects. You don't want them saying, oh, well, you should have told me. Well, nobody told me. Having it down in writing confirms that you've had this conversation. If it's not in the purchase agreement itself, you should have it in written confirmation. So an email, for example, would suffice because it's documented, documentary evidence that you did have this conversation. So have that conversation with your client. Make sure they're comfortable with virtual tours or not completing the purchase of property that they've never seen in person. A lot of agents that work with foreign buyers already deal with this. There are many foreign buyers that purchase property in Ontario without having ever seen the property. So that in itself is not strange, it's not unusual, but in all of what we're doing, it's a best practice strategy so that nothing comes back to haunt you. Again, remember, these are uncharted waters, so we're just trying to navigate properly. So make sure that your client's comfortable all along. And many of you probably have experienced this, but I understand that there are certain sellers that aren't comfortable with showing too much of their property. Some sellers, for the same reason, would rather do exclusives so that their listing doesn't go on MLS. These same sellers, I would imagine, would not want their, like video footage of their property existing on the internet. So they have issues with it. you have to respect that. For many, it's a security issue, and so you have to respect that as well. So those are things that I envisage you going through, like hurdles that you might need to obstacles, if you will, that you might need to get past with respect to doing things virtually. But we have a business strategy. But like I said again, make sure that this conversation documented and that everybody is happy and satisfied to proceed in this manner. A couple other things that I've noted as well with the agreement of purchase and sale. What happens when you've now closed the deal? So now you've able to close the deal virtually, able to do the inspection virtually, and now you've got a firm agreement of purchase and sale. What then happens from that point going forward? What happens if one of the parties, could be the buyer or the seller, happens to fall sick? What do you then do? How does the deal then close? What we are recommending, and I'll send out I'll circulate an email with a couple of suggestions for clauses that you can use in this respect. But what happens when one of the parties either falls ill or is subject to mandatory quarantine? What do you do? Does the deal still go through? Does the deal get put on hold? How do we proceed? What we are recommending is that there's a clause in the agreement that allows you to automatically extend the closing for a 14-day period. Where do we get this 14 days from? That's what's been recommended by the public health agencies as the period within which, more like an incubation period, to clear the fact that you're not yourself infected, with this virus. So 14 days, automatic extension. Then what happens after 14 days? My expectation is that someone who's in quarantine or someone who's hospitalized might not, in those 14 days, be able to do anything. You might not be able to get your mortgage finalized. You might not be able to get your personal items moved, things like that. So I don't expect that at the end of the 14 days, you'll be ready to close. I don't expect that at the end of the 14 days, the lender, banking lender, whatever type lender they're using, will be ready to fund the deal, right at the end of the 14 days. So my suggestion is you have an automatic extension by 14 days. At the end of the 14 days, the parties can pretty much mutually agree to a new closing date. That new closing date can be set at no longer than or no later than, say, 5 business days from the end of the 14-day period. Could be less, could be more, but whatever the parties mutually agree to. So you want to put a date, you want to put a maximum extension date, just to keep all parties in check, so nobody gets to abuse this process. So that's what I'm recommending in terms of quarantine of the respective parties. The other issues that could come up that I've highlighted, I haven't had any issue. I must point this out. Since the pandemic started, I haven't not closed a deal. All of my deals have closed, which has been amazing. Things have progressed differently. Even in my office, we've had to employ, of course, digital measures, so to speak, digital technology measures. Banking is now being done by way of wires. Clients are being met remotely. So that's kind of posed its own challenges, or its own challenge, if you will. But we've gotten through it, and it's, every deal has closed. Everything's gone through quite fine. We've encountered issues with lawyers on the other side who haven't employed the same technology means that we have. So that's been a bit of a challenge, but by and large, things have progressed. So so on my end, I could experience, say, becoming myself a victim, or someone who's subject to mandatory. So what does that? In my case, I work with, my firm's got other lawyers. We've got about 9 other lawyers. So I could always get another lawyer to complete the transaction. But what happens if you're working with a lawyer who's a sole practitioner? A sole practitioner lawyer who becomes a subject of quarantine or is hospitalized cannot proceed to close, which means your deal does not get to close. So there, things like that you need to consider. Speak with whoever you work with. Make sure that they've got plan B, alternative plans, should anything happen to the lawyer as well. All the staff, really, not just the lawyer, all the staff, but especially the lawyer who's on record for this. The law office could get closed. At this point, we are still, classified essential service as you are, but the province has also indicated that this could change at any point. So the list, as we saw it come out on Monday evening, could change over time. So what happens if next week law offices get removed from that list? That could impact closing as well. So it falls back to the same clause that I was talking about earlier. Is should that happen? Should a law office get shut, or should law offices get shut down? Should banks get shut down? An automatic extension goes in effect. So it will be the same strategy as though the parties all of a sudden, for some reason relating to COVID-19, are unable to close. So it would be the same strategy if a law office closed as well. A couple of mortgage brokers that I work with have expressed to me the fact that appraisals are being delayed. So that's another issue that could impact your closing, is where financing isn't able to come through. So as many of you know already, as you all know, when you sign an agreement of purchase and sale, there's a financing condition. The financing condition is waived as soon as you get an approval from the lender. Now, an approval itself isn't 100%, whether we like it or not, isn't 100% guarantee that funding will occur on the closing date, because the lender still has the right to pull the deal should they find, like if they found irregularities in the application, issues with the property, they could still pull the deal or change the terms. So if for some reason an appraiser isn't able to go out to the property because they're either A, not working, or B, working very slowly, that could impact your client's closing. So what I'm recommending here is, when it comes to financing, before your client waives the financing condition, have them check with their mortgage broker, have them check with their lender that there will not be a problem funding the deal. There won't be a problem relating to COVID-19, which most likely would be, inability to get an appraiser out to the property, getting in the way of funding the transaction. So that's extremely important, and I think that you should impress that upon your client, so that they don't get stuck, basically. Powers of attorney. Now, power of attorney, there are two main powers of attorney. There's power of attorney for property, and there's power of attorney for personal care. The one that we care about, where real estate transactions are concerned, would be power of attorney for property. which basically allows somebody else to complete, to enter into and complete a transaction for you. So if you were going to be out of town, for example, or for some reason not available, you could designate someone as your attorney to enter into an agreement of purchase and sale, to sign closing documents, things like that, just to ensure that your obligations are still met. In this climate, in this current climate, any one of us could fall sick at any point. So have we thought about ways that our contractual obligations would be carried out or would be fulfilled? Same applies to your buyer clients and your seller clients. If they feel sick, what then happens? I know we talked about the automatic extension for 14 days and then coming back after 14 days and trying to get a further extension. But what if they are incapacitated for much longer? So a power of attorney is not such a bad idea in this climate, for everybody to have, quite frankly, especially for your clients who are entering into agreements of purchase and sale to have. Now, a power of attorney could be subject to certain restrictions. So there are certain lenders that will not allow you close using a power of attorney. This was pre-COVID-19. I haven't heard any of them change their requirements as a result of COVID-19. But bear in mind that a power of attorney would not necessarily work in every situation. So the alternative lenders generally, your home trusts and the rest of them, generally will not allow you close use under a power of attorney, using a power of attorney. Insurance, that could be another concern. So if your client has to get an insurance policy, especially when they're not buying cash. So if your purchaser client is buying property by way of a mortgage, they're financing it, the lender would need them to get fire insurance coverage that notes the lender as a loss payee. If certain insurers will not issue will not issue insurance coverage or an insurance binder without having sent out an adjuster or someone to at least assess the property, just so they know that the property exists, just so they know what problems there are with the property, just so they know if it's got knob and tube wiring, or like things that they want to know what they're insuring basically. Now, if the insurance company isn't able to send out somebody, that you're not able to get insurance, or rather your client's not able to, the buyer client isn't able to get insurance, then you can't close. So that's another issue that could come up in that respect. So insurance, when they call the insurance company, make sure that they find out if there will be any issues getting insurance. A solution to that could be, if they're not able to, if the insurance company runs into problems, they could always use the insurer that the seller already has in the interim, just to get them past the closing of the transaction. Is that they could insure, the existing insurer basically continues the insurance, but then switches over the owner and the loss payee. So that's an option in the event that the insurance company or your clients aren't able to obtain insurance coverage. Movers have been designated essential service. So at this point, as we speak, movers can still work, but that could change very quickly as well. So have your clients bear that in mind. With moving, all of a sudden there could be a problem with that. Storage, storing their personal items, there could be a problem with that as well. The agreement of purchase and sale, many of you already do this because you use DocuSign and you send documents through other electronic means. there's a clause that most of you already put in the agreement that says that in accordance with the Electronic Commerce Act, the parties can sign this document electronically. The document, the clause generally refers to the agreement of purchase and sale. What we needed to do, well, what we needed to be able to cover in this times is for closing documents to also be signed electronically. Now, many lawyers are on the same page in this respect, so it might not be such a big concern. But in the event we run into that lawyer who tries to be difficult and is insisting on receiving original documents when in actual fact we can't meet with the client physically, by expanding on that clause, and expanding on it just basically means you extend it to cover signing of closing documents as well, not just the agreement of purchase and sale. You've in effect enabled closing by way of electronic execution of documents or digital execution of documents. So that by you doing that at the point where the agreement has not firmed up or the agreement is about to firm up, you've helped the transaction. So if you can do that, that would be great. I'll send out a clause in that respect as well. So in respect of the extension and in respect of being able to sign documents electronically. So I'll send that out too. Key exchange. So to again further reduce the need for direct contact, we are encouraging at this point, and we've encouraged it for a little while now, but we're encouraging at this point for agents to leave keys in lock boxes. So that way, if we run into a problem with, let me back up a little bit. The standard way, the most common way for key exchange is that a seller gives the keys to their lawyer or his or her lawyer. The seller's lawyer then sends the keys to the buyer's lawyer. When closing occurs, the buyer picks up the keys from the buyer's lawyer. So it exchanges hands basically, almost 4 times. Seller to seller's lawyer to buyer's lawyer to buyer. We're able to eliminate this by just simply retaining the lockbox at the property and leaving the keys in the lockbox. What then happens is on the closing date, the seller's lawyer releases the lockbox code to the buyer's lawyer. So that way, once the deal's done, buyer's lawyer releases the code to the buyer, and the buyer can access the property. So a number of people already do this. We found it to be extremely effective in this climate as well. So we urge you to do more of that. I think it will just keep everybody a lot safer, and it would allow us, allow things move smoothly. Transactions close a lot more smoothly. Another issue that I'd like to discuss is with tenancies. So at this point, the landlord-tenant board is closed, is suspended. Further, the province has announced that eviction orders aren't being carried out. So if you need to kick a tenant out, if your landlord client or your seller client needs to kick a tenant out now, it will not happen. So you have to bear that in mind, and especially how it impacts your transaction. So if you've got a new tenant taking up a lease, if you've got a buyer who's supposed to be taking vacant possession, but the seller isn't able to provide vacant possession because the tenants refuse to move, that would definitely impact your transaction. So that's something else that you need to bear in mind at this point. The LTB, that's a landlord tenant board in Ontario, have said that they're able to, in exceptional circumstances, and quite frankly, Not clear what that would be, but they're able to, where they can, do telephone hearings or hearings in writing. How effective that would be, especially the one in writing, I really don't know. I really question that. The telephone one could work, but how do you get them to get in there within, such a short period of time? Because you've got a closing date coming up, and all of a sudden, you're caught up in this problem of trying to get rid of the tenant. So that's something else you have to keep in mind where tenancies are concerned, whether it's with respect to your lease agreement, whether it's with respect to a purchase and sale agreement, where you need to give vacant possession. Have conversations with your client. If your buyer client, realizing what's going on, recognizing it, and being and open to working with it, is willing to close anyway and assume the tenancy for a period of time and then deal with all of the trouble later, that's possible too. If they're willing to do that, make sure that the seller's lawyer holds back funds. So basically, the deal gets closed, so the transaction is done. Title is now in the buyer's name, but the buyer has no possession. It opens a can of worms, admittedly. There's no question about that. It does open a can of worms. Potential if the tenant still refuses to move out, which then means that they have to go through the process of evicting the tenant. But if the seller, if you can get the seller's lawyer to hang on to the funds, so the proceeds of the sale don't get released to the seller, that at least gives the buyer some level of comfort. So if you had an undertaking or terms of closing that says, look, there's $100,000 net proceeds, hold on to 50,000 or hold on to the entire 100,000, and any cost of the buyer in getting rid of the tenant post-closing would be covered by that amount that's held back. So that gives the buyer some level of comfort, but at the same time, you have to make sure that the buyer is comfortable proceeding this way. Otherwise, it's just best to not proceed at all and just wait till everything settles and they're able to get vacant possession. But for the seller, at least the property is closed. It's just a function of getting through what situation we found ourselves in as a result of the pandemic, which hopefully can be dealt with as soon as possible after everything goes back to normalcy. Problem is, we don't know when everything will go back to normalcy. It could happen in 3 weeks. It could happen in 3 months. It's anybody's guess at this point. So that's another concern. One last thing, so I can start to also entertain your questions, and if anybody else has to speak, they also get the chance to speak as well. Pre-construction. So some of you might have clients or personally have bought pre-construction properties. In the last week or so, you probably got email from the builder advising you of an avoidable delay as a result of COVID-19 pandemic. I got a lot of clients reach out to me in this respect, so I would imagine you did as well. What the email is about essentially is basically saying that because the delay is no fault of the builders, it doesn't count towards a delay in delivering the property. Why is that important? Under Tarion, which is the new home warranty program, if a builder does not deliver property to a buyer by a certain date, the builder has to compensate the buyer $150 per day to a maximum amount of $7,500. So what the builder's trying to do here is make the buyer aware that any delay that's occasioned by this pandemic will not count towards the delay in delivering the property. So that's it. That's basically what it is. A lot of my clients, contacted me and they wanted to know what they should do, if they should do anything, or what does this mean. And I told them, no, you don't have to action anything. It's just FYI. And this is what it means. It basically just means that it suspends the delay period that the builder is responsible for. So that's basically it. Over time, I mean, this is all new. This is all unprecedented. But I'm sure over time, certain things will come up, and we'll have to, we'll update you every now and again as things progress. But at this point, these really are the issues that you have to keep in mind and figure out how to best navigate.
Okay, thank you very much, Yemi, for your time and the information you shared with us. Just before we go to the Q&A, this webcast will be available on the Pickers YouTube channel if somebody wants to revisit it or ask other people to come and look at it. So there were a couple of questions, and I encourage other people who are on the chat as well to, if they have questions, please leave it there. There are a couple of questions that I already have for you. First of all, regarding the tenancy, you talked about it, but what happens if just a tenant refuses to pay the rent, or he or she doesn't have any money to pay?
Well, at this point, the law is still status quo. Rent is due on when it's due. A lot of rent will be due on April 1st, but rent is still due when it's due. As of this morning, there hasn't been an official position in Ontario as to rent relief. So if you don't pay rent on April 1st, or if you don't pay your mortgage, you are in default. That's where things stand right now. That could change. That could change over time, but as we speak, nothing has changed. What the mayor of Toronto has done is sent out a plea to landlords to work with their tenants. It's not a legally binding statement. It's just a plea to appeal to, or rather to appease to the humanitarian aspect of what's going on, and expecting the landlord to be considerate. But no, rent is still due. That's a short form answer.
Okay. So the other question is about the tenants who are supposed to vacate a property. Now they cannot vacate it because of the dire situation out there. Say June 1st, somebody had to vacate it, but now they can't. What are their options?
For the landlord?
For the tenant.
For the tenant themselves. So if a tenant was supposed to vacate and the tenant can't because they're restricted from, it's more so a landlord problem. So the landlord then has to figure out, okay, what does this mean for me? Are they still officially my tenants? Do they still owe me rent? So those things still, like, again, status quo is still the same. If you don't leave, then it's overholding. You've stayed beyond the term of your lease. Like, it actually doesn't quite change anything at this point. So situation is still the same. It becomes the issue there becomes, if the landlord's already lined up a new tenant to start, to commence a lease. So if you've got a new tenant coming in on June 1st, but your client that was supposed to have left on May 31st can't leave, your first problem as a landlord is to work out something with the tenant that's coming in on June 1st. Because right there and then, you're not able to deliver the property. So if you want to negotiate an extension so that they start, they commence their lease on maybe July 1st, and then you agree to cover their cost or half their cost for the month of June, you have to negotiate something with that.
So it's a very hard thing to be a landlord right now.
It is, indeed it is. And hopefully there's some type of relief measure from the government whereby landlords that have lost money as a result of this are eventually compensated. So my advice to any landlord now is any arrangement that you agree to, document it. Just document it, show proof that, hey, this is what I receive every month in rent. My tenant specifically requested that because of COVID-19. Now, remember, it has to relate to the pandemic. It can't be any tenant who just wishes to not pay. And like in any system, people will abuse the situation, So, but when you're trying to claim money from the government, trust me, they will be asking you for paperwork like you won't believe. So I think it's important at this point to document everything and document the tenant's request, document the fact that the tenant is making that request because of COVID-19. The previous lease you already have, so you can already confirm. You can already confirm how much is paid in monthly rent, and just as much as you can document.
Thank you very much. Next question. The gentleman asking about saying that my buyer client has lost his job because of these days happenings, wants to get out of a firm deal. Do we have any ground?
There's no contractual ground. On the face of it, there's no contractual ground. You've signed an agreement and it's firm, especially if it's firm, there's no contractual ground. What I would recommend is it's worth reaching out to the seller regardless and hope that with the seller you can reach some type of agreement and get a release.
Okay.
If you don't try, you'd never know. So it's worth going back. I would imagine most sellers probably don't want to release, a buyer because they're probably concerned themselves in their ability to resell the property. Because, like it all depends on who you're dealing with. But I would imagine the average seller would be nervous at this point about their ability to resell the property. So, but nonetheless, you just have to approach and ask. You have to approach and ask. Another option for your buyer client is see if you can assign it.
Oh.
You can assign the agreement as well. So compared to a builder deal where you have to go back to the builder to get a consent to assign, with a resale, if you're using the standard OREA form, unless you've written something into the schedule, you don't need the seller's consent. So if I was in that situation, next thing I'll be looking to do is assign it to someone. And when you're assigning it, forget making money. Like in a typical assignment, you're signing to make money. In this case, you just want to be able to walk away from your obligation. Just assign it for the same amount if that's what you have to do. That way you save your deposit, and that way you're now, when the deal closes, you're no longer bound or obligated under the agreement. So that would be my recommendation.
Again, thank you very much for your time, Mr. Yemi.
You're most welcome.
Thank you. And this webcast is going to be available on PICRA's YouTube channel. I know all the volunteers at PICRA and the board of directors are committed to helping you guys with this during this hard time, and we are trying to get you weekly webcasts every week from now on. Please take care of yourself. Please reduce and eliminate unnecessary in-person interactions. Stay at home, stay safe, and hopefully see you guys on the other side of this epidemic as soon as possible. Okay? Take care for now.
Thank you. Take care, everybody.